will resume the session, and the representation of the respondent has the floor. It's your turn, Mr. Horta.
Thank you, Mr. Chairman. Heavy on rhetoric and very light on proof. Say that again. Very heavy on rhetoric and very light on proof. That's the other side's case. They've tried to assemble a case given the lack of real proof, and you've seen it in their presentation, based on newspaper articles, supposed comments made by the President, the Attorney General, after the Lesivo Declaration. And they do so because there's no evidence of the allegations that they would like for you to sustain. None. We're going to talk about the actual evidence. It's a serious case. They're seeking $65 million from the Republic of Guatemala. It's the first CAFTA case ever filed. And I submit to you that when you dig in and look at the actual proof, the reliable proof, what was really said between the parties, what was really discussed, what documents were really exchanged, that you will come to the conclusion that while claimant has made a number of very serious allegations against the Republic of Guatemala, 3.5 years later, they've been unable to prove them. I submit to you that relying upon newspaper articles, we all know how unreliable the press can be in reporting what is said to them. I submit to you that if that's the best they can do, that speaks volumes for the lack of proof in their case. What is this case really about? RDC in 1997 submitted to a public bid that was put out by the government of Guatemala to have their railway modernized and restored. That's what the government of Guatemala was asking for in its public bid, and that's what RDC through FVG, its local enterprise, bid for, and that's what it won. And it promised to modernize and restore the railway. Now, they've told you it was a very risky investment. They told you that the railroad was in a bad state, inoperable, full of squatters. They knew all of this. Their presentation says so. The documents that were in the bid tell you that. Now, RDC never fulfilled its promise to its investment, never fulfilled the promise that it laid out in its proposal. Okay? The government of Guatemala expected to get a modernized and rehabilitated railroad. As we sit here today, over 13 years after that bid was issued and won by RDC, there is no modernized rail system in Guatemala, none. So we're going to talk about in a little bit, that's not what this tribunal is here to decide, but it is relevant. It's relevant because, as we'll talk about in a bit, it makes perfect sense that the government of Guatemala and claimant were discussing a host of issues that they had in dispute between them. And there's been a lot of talk and a lot made about a settlement proposal that was given the day before the Lesivo Declaration was published. There's absolutely nothing strange about the fact that the government of Guatemala and claimant were trying to settle a number of issues they had in dispute. Now, the investment never fulfilled the promise for a number of important reasons. They made a number of projections, RDC did, about demand for its services in Guatemala, about the possible tonnage, about real estate revenues that they thought that they were going to be able to obtain, and about funding, both from private and funding sources that they thought that they would have. The problem is that as to each and every projection they made, they were off the mark. And you don't have to accept my word for it. You don't have to accept Guatemala's word for it. all you need do is look at their business plan, look at what they actually achieved, and look at their reports, their annual reports to their shareholders. Just read through them, and you'll come to that conclusion. Now, today, as I mentioned, Guatemala is still waiting for a modernized railway. They've only rehabilitated one of the 5 phases. It's the one that's in red here. And the undisputed evidence in this case, it's not rebutted, is that that's the only phase that they were able to complete between the time they started and the time they left the country unilaterally on their own in 2007. And they tell you that they in fact have no real intention of doing any of the other phases. I submit to you that the evidence is a bit different. The evidence, what it will support, is that they rehabilitated the first phase, but the problem that they had was that the second, third, and fourth, and fifth phases presented big problems to them. And I put the picture back up just to highlight for you what is in green on the screen. That is the second phase. And there's undisputed evidence in this case that there was a lot of effort made, mobility on behalf of the government, and some effort made on behalf of RDC to try to make that second phase a success, to try to put it into action. But there was a very important limitation. Okay? They took this investment on, and they agreed, both in the contract and through the bidding terms, to do it at their own risk and expense. That's what the contract says, at their own risk and expense. And the problem that they had is that they never were able to come up with the funding to do the second phase. And the reason that was such a problem for them is that the only phase that they did rehabilitate, phase 1, produced nothing but losses for them from inception until they left the country. So without being able to do the second phase, which they themselves admit they had no funding to do, they were stuck with a failed investment. And this all happened, before the president declared Lesivo their equipment contract. Now, putting into context a little bit what we're here to talk about, let's remember that claimant has an investment. And they tell you that their investment is not the equipment contract. Their investment is a much broader set of agreements to restore the railway, and part of that was the equipment contract that was declared Lesivo. Now that's important because when we get into the business of analyzing whether or not Guatemala has violated any of its undertakings under CAFTA, and in particular when we get into analyzing whether there's been an expropriation, you will see that they admit freely that the largest part of their investment, Contract 402, and the most important part of that investment, their ability to generate real estate revenues, is wholly unconnected with the contract that was declared Lesivo. And the evidence we submit shows that the leases that they were able to obtain pre-Lesivo, they still have. And the revenues from those leases have gone up. They stipulated to that. That is unrebutted. Now, going back to the historical important points of this matter. Separate and aside from the real estate restoration contract that they had, they participated in and won a bid for rail equipment. We all know that. The contract never came into force. The initial contract never came into force. And it didn't because there was a very important requirement. And that's something that was stipulated to in the bid conditions, and it was repeated in the contract. Before the FEGWA overseer could grant to them and usufruct the equipment, he had to have approval from the President and the Cabinet. And that approval had to come after the contract was signed. Now, that contract was never signed. And it's important to remember that that is not this case. This case is not about that contract. That contract was not declared Lesivo. This case is not about whether or why the government, the President and his Cabinet, did not approve that agreement. Why? Because FVG and the then overseer of FEGWA signed a new agreement that terminated the prior contract. Okay? That agreement is not the subject of this case. What is the subject of this case is what claimant did after that. Okay? They had the ability, and this is something that we went through during the jurisdictional phase, they had the ability to seek through judicial means to seek an understanding as to why the president didn't approve the first contract, and to go to the courts and compel the president to say why he didn't, and to determine yes or no whether he would approve. That was the legal remedy that they had available to them in the absence of approval of that contract. And I think it's important to highlight here that during the time that they didn't have approval, the government through, well, the railway agency nonetheless did give them access to the equipment, did let them operate through these letter authorizations that we've talked about. Whether right or wrong, from a legal standpoint, it's clear that the government didn't stand in their way. The government, in good faith, the railway agency allowed them to use the equipment through these letter authorizations. But importantly, all of that, while it does set the stage for some of the issues that are to be discussed in this case is not about Contract 41. It's also important to realize that while we can speculate about the reasons, something compelled the prior overseer to enter into Contract 143 and 158, even though, and this is part of the record, we know that his then lawyer in FEGWA advised him not to do so and told him that that agreement didn't comply with Guatemalan law. Now, what happened after that? Well, upon discovering, and this is just months after they signed the contract that is at issue in this case, the equipment contract, Guatemala used its Lesivo law, which was and had been in place for over 100 years before claimant made its investment. So claimant should have known about that law when it made its investment, and it agreed to abide by all Guatemalan laws when it made its investment, including the Lesivo law. And it used that law to challenge this contract because it suffered from a number of very important illegalities. The government, through the president, after being asked by the FEGWA overseer to declare that contract Lesivo, and after taking very careful steps to analyze whether the contract was Lesivo through a number of government agencies, declared it Lesivo. And let's remember what that means. A declaration by the president that a contract, an administrative contract is Lesivo, is nothing more than an internal determination made by the president that the contract suffers from some defects that cause lesion to the country of Guatemala. And it's his way, and his only legal way, to signal to the Attorney General that there's something wrong with the contract and that the Attorney General, as the lawyer for the state, should take that contract and bring it to the judiciary, the independent judiciary, so that the court can then determine whether the contract is or is not Lesivo, and whatever remedies might result from that determination. So the point is, at the time the president declares the agreement Lesivo, it has no effect on claimants' legal rights under the agreements. None. And that's not disputed. Both experts on both sides agree to that in this case. Now, notwithstanding that that was the case, notwithstanding that claimant, as we sit here today, has every single right that it ever had, whatever they may be, under the agreement that was declared Lesivo, and has every right under the larger part of their investment, the railway restoration contract, which was not declared Lesivo, notwithstanding that they have all of those legal rights, they seized upon the declaration of Lesivo, and 1 business day after that declaration was filed, they published to the world that their investment had been destroyed and that they were going to be forced to leave the country. That's a matter of record in this case. They used this case as their golden parachute out of a failed investment. That, at bottom, is what this case is really about. Now, what are the primary issues? We all know that there are a number of legal issues under CAFTA that we're going to have to discuss. But what is the, at bottom, when you strip everything away, what is it that you're really being asked to decide? We submit to you that what you're really being asked to decide is what's up on the board here as point number 1. Whether Guatemala violated any CAFTA undertakings when it applied its pre-existing Lesivo law to declare the equipment contract Lesivo when that contract failed to meet several essential requirements of Guatemalan law. That's the real issue. And separately, but relatedly, whether claimant should be allowed to shift to Guatemala through this claim responsibility for its failed and risky investment. We submit to you that when you look at the evidence, you have to conclude that claimant's investment in Guatemala was a failure. They made a number of projections, but those projections were very off the mark. They never achieved what they thought they would achieve, and they were in much, much trouble in 2006 when the Lesivo Declaration was issued. All right, going through now some of the factual points in a bit more detail. We've talked about the fact that the claimant made a very risky investment in 1997 to operate and modernize the railway, and that it did so at its own risk and at its own expense. Now again, the problem, it did so with limited capital and funding. They tell you that. They tell you they only ever agreed to invest $10 million. And they tell you they invested a little bit more than that, but that was much, much too little money for the project that they undertook. How do we know that? Because they themselves admit that it was going to take over $100 million to do phase 2 of the 5-phase project. Over $100 million. Now, if you look at their business plan, they talk about all sorts of third-party funding that they were contemplating getting. And they made all sorts of promises about funding, but none of that funding came to fruition. They had a bare-bones budget, an agreement, they say, to invest only $10 million, and that got them no more than restoration of the first phase of the project. And we know, you don't have to accept my word for it, we know from the facts that phase 1 produced only losses for them. How did they keep from bankruptcy? Well, we know that too, and they've admitted it. And again, their financial records tell you so. Every year, they had to get their shareholders to contribute more capital to keep them afloat, to keep them from going into bankruptcy. They looked at the restoration of the second phase, and if you read the statements of their witnesses, and if you read some of the evidence that we submitted, they understood that they had to restore the second phase in order to make this a viable investment. But as I said before, they didn't have the funding for that project. And again, they couldn't get the funding. So they were stuck with, as I've mentioned, a failed investment. And again, they're using this case as their exit strategy. Now, there's been much made about the fact that the claimant says that Guatemala should not be entitled, should be stopped from making arguments about the illegality of Contract 143 in this case. They say they reasonably relied upon representations of the FEGWA overseer at the time to enter into that agreement, but that is not true. That is just simply not true. And how do we know that? Again, you don't have to accept our word for it. They knew they were entering into an illegal contract, and public international law tells us that one cannot profit from their own misconduct. How did they know that they were entering into an illegal contract? Well, this contract had a precursor, and that's why Contract 41 is relevant here. And that precursor contract, Contract 41, required a public bid before claimant could have access to the equipment, and required a contract that by its terms would not enter into force unless and until the President and his cabinet ministers approved that agreement. They knew that when they signed Contract 143 and 158. Not only did they know it, but they put in the terms of the agreement that requirement was unnecessary, even though they incorporated the very bid terms that set that forth as a requirement. Even though the Constitution of Guatemala requires that President and that executive and cabinet approval before the FEGWA overseer can give the equipment in usufruct. So they knowingly disregarded an essential requirement of law in Guatemala when they entered into that agreement. Not only as it relates to the executive approval, but as it relates to the need for another public bid. This other contract was entered into 6 years after the first public bid. You're going to hear, and you've heard from Dr. Juan Luis Aguilar, Guatemala's expert on Guatemalan law, who tells you that whenever you give equipment, state equipment, whenever you give it to a third party, including through a usufruct, it requires a public bid. And it matters not that there was an original public bid 6 years earlier, conditions change. So Guatemalan law requires that if you're going to have a separate contract, especially a contract that varies the bids of the initial bidding terms, you've got to celebrate another public bid. And compliance with public bidding laws is a serious thing. Of course that relates to a public purpose. It's not some mere technicality as claimant would have you believe. So when they entered into this agreement, they did so without conducting a public bid, incorporating bidding terms that they disregarded, and interestingly entering into a number of backdated leases to justify payments of cannons that they owed to FEGWA based on these letter authorizations that they had executed. Now, they claim estoppel. They claim, gosh, we entered into this agreement, the FEGWA overseer told us it was okay, how can you declare it lesivo? Well, look at their actions. Look at what actually happened. The agreements are entered into, the first one in August of 2003, the second in October of 2003. That was right before the change of an administration in Guatemala. President Berger Azum's office in 2004, and there's a new FEGWA overseer appointed, Dr. Gramajo. The very first request they make to Dr. Gramajo under the new contract, what does he do with it? He responds to them, sorry, you've asked for equipment under this contract, but the contract suffers from a number of illegalities. And those illegalities need to be cured. And therefore, I cannot honor your request. So the government didn't ratify the contract. The government immediately told them that there were problems with it. And the course of dealing between the parties from the very first request they make to the new FEGWA overseer in early 2004, only months after they entered into the agreement, all the way through and after the government declared that contract lesivo, show that the government never ratified the agreement. And their conduct shows that they understood that the government never ratified the agreement. The payments that FEGWA received for their use of the equipment throughout this period was per the letter authorizations that they themselves had proposed to the government, and which the government in good faith accepted so that they could have use of the equipment while the issue of the contract was sorted out. And importantly, Monday afternoon quarterbacking is very easy. When you look at the contemporaneous evidence, and that's really what we need to look at here to make the decision, right? when you look at the contemporaneous evidence, where is the evidence that they were claiming between 2003 and 2006 that the government should be stopped from declaring that contract illegal, or should be stopped from saying that that contract was not enforced? Where's their letter that says that? Where's their complaint that says that? That's a litigation-driven theory. That's something that was put together for purposes of this case. But there's no contemporaneous evidence of that. The evidence is different. The evidence shows you that the parties, immediately after Dr. Gramajo told them that there was a problem with this contract, started exchanging draft agreements. We have email correspondence from their lawyer sending a draft agreement to FEGWA in which they're trying to come up with a new contract that would fix some of the illegalities. Again, you don't have to accept Guatemala's word. Let's look at the evidence. They wrote in November of 2004 to the Vice Minister of Communications, copying the President of the country and a number of other high-level officials. And what did they ask for, in part? Official and formal recognition of their contract. Here's the letter, okay, dated 15 November 2004. They're asking for official and formal acknowledgement of their contract. And they say the government's failure to acknowledge these contracts. That's clearly not the government ratifying those contracts. They're acknowledging the government is doing just the opposite. It's telling them the contracts have problems, legal problems, important ones, that need to be fixed before the government will acknowledge them, before the government will operate under them. This is their letter. And they also acknowledge in the second paragraph that the government and they were in negotiations to try to fix these problems. This is not the government ratifying. This is not estoppel. They acknowledge it. And they themselves say that they're negotiating with the government to come up with a new contract or a modified contract that would address the government's concerns, that would address FEGWA's concerns. So they knew that the government had told them there were problems, and they were trying to fix them along with the government. They were meeting with the government. So it's just not the case that the government ever ratified this illegal contract. What the government did, though, and the evidence does show this, is that from 2004 up to and including the period when the contract was declared lesivo, and after, the government in good faith tried to negotiate a resolution of the issues that caused that agreement to be lesivo, as well as a number of other issues that were in dispute between the parties. Now, there's been much back and forth between the parties about whether the claimant performed its obligations or Guatemala performed its obligations under the various contracts. As I mentioned before, that issue is not one that the tribunal need decide. But it is important for the tribunal to understand that that issue does have relevance in this case. And in terms of the legal issues that need to be decided by this tribunal, the most relevant aspect of this is that the parties were negotiating a number of different disputes between them. Guatemala asked for a railroad, put a bid out for it, and it feels misled because while claimant promised to restore and modernize the railway, Guatemala to this day doesn't have that promise fulfilled. And there are a number of other promises, and we list them here. Payments, they made certain projections about what they would pay, and those projections were far short of what Guatemala actually received. And a number of other promises. But again, important that you recognize that that's not an issue that you need to resolve, but when you look at some of the things that they're pointing out, why was the government discussing with them the broader problems with the railway during the same time that they were discussing the lesivo declaration? Well, there's no surprise as to why, because that was an issue that was in dispute between the parties. Now, as it relates to the issue of the Lesivo declaration, we submit to you, again, there's been a number of expert reports back and forth about whether the contract, the equipment contract, is in fact Lesivo. That issue is before the local Guatemalan court. That is not an issue that this tribunal need decide. The question is, we think, whether Guatemala violated CAFTA in determining that the contract was Lesivo, in the process leading up to the declaration of Lesivo. What did Guatemala do? And what was it trying to remedy? Now, on that issue, it's undisputed evidence. Now it's undisputed in this case that the persons who were analyzing whether the equipment contract was Lesivo, that is, the persons in each of the different offices of the government that were asked to do that, they all independently concluded that the contract was Lesivo. You've seen their legal opinions. None of them, and they've all put in declarations, claimant has chose not to cross any of them, none of them received an instruction to reach that conclusion, that the contract was Lesivo. They independently, after objective analyses, reached that opinion. And none of them knew about this alleged and, we submit, completely unproven conspiracy to give the concession to Mr. Campoyo. They've all told you that by way of written declarations, and the other side has chosen not to cross any of them. Now, talking about the issue of Mr. Campoyo, I mean, if stripped again away to its essence, what claimant says in this case is that the government had certain improper motivations in declaring the contract Lesivo. One of them, they say, is to benefit Mr. Ramon Campoyo, who is a businessman in Guatemala who is in the sugar industry, not the railroad industry. Their allegation in this regard is unproven. Again, I submit to you, it's very easy to level allegations, but when it comes down to it, where is the evidence? Where is the proof? Claimant has produced no document, no evidence that demonstrates that Mr. Campoyo or anyone on his behalf asked the government to take away the railway concession from claimant to give it to Mr. Campoyo. That's their allegation, but there is not one piece of evidence that will support that conclusion. They've produced no evidence that the government has given or offered to give the concession to Mr. Campoyo. Here we are, 4 years after claimant left the country, 5 years after the contract was declared Lesivo. Where's the evidence that Mr. Campoyo went to the government and said, hey, great, we've achieved our objective to declare their contract Lesivo. Now give me the concession. Where's the evidence that he even asked for the concession, even without an admission like that? It's non-existent because it is a theory that is unproven. It simply didn't happen. All of the government officials involved at the highest levels, respected individuals in the administration of Mr. Berger, as well as Mr. Campoyo, as well as President Berger's son, deny that this was ever a motive of the government. It wasn't, and there's no evidence to prove it. The other pillar of their improper motivation argument is that the government used the Lesivo Declaration as a threat instrument. There's a series of fundamental flaws with that argument that they've made. Again, it's a theory, but it's unproven because it didn't happen. The President issued the Lesivo Declaration, and this is what the evidence shows, because the contract at issue suffered from a number of important defects, and the President was consistently told that. The evidence shows that he was told that by the Attorney General of the country, by the overseer of FEGWA, who independently had that issue analyzed by internal lawyers and external lawyers. And what did the government do when he receives the request from the FEGWA overseer to declare the contract Lesivo? Does he immediately sign a declaration and declare the contract Lesivo? No. He has the issue analyzed by his internal legal team, who in turn sends it to the Ministry of Public Finance. And they have it analyzed by 3 separate lawyers, all of whom conclude that the contract is lesivo to the interests of Guatemala for a number of fundamental and important reasons. And the President is told that if he does not declare the contract lesivo, that he will face legal consequences. That's why the lesivo declaration was issued. Not because, as they say, there was any conspiracy to benefit Mr. Campollo, and not because, as they say, the government was using the lesivo declaration as some kind of instrument or weapon to force them to renegotiate their contracts. Again, where's the evidence? What does the evidence actually show? Well, we know, and this is uncontested, that in May of 2006, they got wind of the fact that the government was analyzing the possibility of declaring one of their contracts lesivo. We now know it's the equipment contract. And how did they learn this? Because a government official, somebody within the Berger administration, picked up the phone and called them and told them that. What was the government's response when they complained about it? This is uncontested. The government stopped the lesivo process. The government said, we'll put it on hold, and as a measure of good faith, we're going to give the parties more time to try to negotiate a solution. Where's the evidence that the government used the lesivo declaration as a threat instrument? It's the opposite. The government put the lesivo process on hold to give the parties time to negotiate. It's just the opposite of what they're saying. Now, claimant also tells you, in an effort to sustain their arguments on fair and equitable treatment, that the government didn't tell them about the lesivo declaration until a day before it was set to be published and after the President had signed it. I submit to you the following question. How can one use as a threat something that they don't tell the other side about? The answer is you can't. When you threaten somebody with something, you obviously tell them about it. You wield it over their head and you say, either you do this or I'm going to do that. There's no evidence that the government did that with the lesivo declaration. Just the opposite. And their allegations prove it. Now, they point to the agreement that was exchanged on the 24th of August, the day before the lesivo declaration was set to be published. And they say, this is evidence that the government used the lesivo declaration against us as a threat instrument. No, it's not. All that is the government's effort, as it had been doing ever since they first got involved with FEG and claimant, to try to come up with a solution, a negotiation, to try to resolve the disputes. And I submit to you that there is nothing unusual about the fact that that agreement addresses globally a number of issues that the parties had in dispute. Nowhere in that agreement does it say, unless you do X, we will issue the lesivo declaration. The only other document they cite for this theory, other than these unreliable newspaper articles, or the one unreliable newspaper article, are minutes from post-lesivo meetings that the government had with them. And again, I submit to you it makes no sense. If what they're saying is true, if the government's incentive here was take the concession away from them to give it to another party, why would the President be asking his government and his officials to continue to negotiate with them to try to get a working railroad? It makes no sense. And as it relates to this particular document that they cite, R36, it's minutes of a private meeting wherein there's a note taken that the Attorney General then of Guatemala told other government officials, where claimant they had no representatives, that he had to proceed with the filing of the case before the administrative court. And we all know that it's been established under Guatemalan law he had 3 months to do that, or else he would lose the right to do that. The government would lose the right to proceed to present the case before the administrative court. It's a statute of limitations issue. And the statement, I submit to you when you analyze it carefully, all that it says is, I have to proceed with this case, and perhaps the filing of that case might act as a bit of pressure to get the parties to come together as to the settlement issues. That's what it says. That doesn't say we're using the Lesivo Declaration as an instrument to pressure the claimants to renegotiate their agreements. And more importantly than that, it's a statement made in a private meeting. It's not a threat made to them. Where's the evidence that they knew about that somebody communicated that statement from the Attorney General to them at the time? It's not there. They tell you themselves that they first learned about that during this litigation. There's no evidence. So, on this point, sum up with the following. There's no evidence to prove that the government has used the Lesivo Declaration as a threat instrument, and had there been, we would have expected claimant at the time to have complained to the government about it. Again, I submit to you in the same way that they didn't do so in relation to Mr. Campoyo, they didn't do so here because it just didn't happen. Now, as to the issue of the effect that the Lesivo Declaration had, it's important to set, again, the stage on some issues that are not in dispute. Claimant admits that today it has every legal right that it had before the Lesivo Declaration in relation to Contract 143 and 158, and obviously the same as it relates to Contract 402, because that was not even the subject of the Lesivo Declaration. It concedes that the most substantial part of its investment is not the contract that was declared Lesivo, but the rail restoration contract, and that the government has taken no action as it relates to that contract. Notwithstanding that they come here and tell you that their entire investment is wiped out, they still have every right under those agreements. They are still benefiting from those agreements. They are still generating revenue from those agreements. And in fact, they have conceded that their revenues have increased since the Lesivo Declaration from those agreements. As we sit here today, they remain in possession not only of their rights for the railway, for the rail right-of-way, the real estate, they also remain in possession of all of the rail equipment. And all of the documents from the government after the Lesivo Declaration all show you that the government continues until the process plays itself out in the Guatemalan courts to respect whatever rights they may have under those agreements. Now, in terms of what could Guatemala have done, Guatemala could not simply have confiscated their rail equipment. Some questions were raised during the jurisdictional phase. Why didn't Guatemala just go and take the equipment back if the agreement was illegal, if it was a nullity, in Guatemala's opinion? Well, because there's a legal process to be followed in Guatemala. It couldn't just declare the contract a nullity. It couldn't just walk in and take their equipment. Had they done so, claimant would have been in here arguing that there was a violation of international law, direct expropriation. There was a process to be followed, and that process required an analysis of whether the contract was against the interests of the state. It required a request to the President, a determination by the President that the contract was Lesivo, and an opening of a court proceeding so that an independent judiciary could make a determination as to whether the contract is or is not Lesivo and what remedies may lie in light of that determination. And that's what the government did. It followed its laws, as claimant should have expected it to do. There were no other legal remedies available. Claimant has made much of the fact that there were other legal remedies that maybe the government should have taken. Well, both experts agree that at the time that the Lesivo Declaration was issued in 2006, the only remedy available to the government legally under its laws was to move forward with the Lesivo process. It was either that or accept the illegal contract and ratify it by inaction. That was simply not an action that the government could take. Now, claimant alleges $65 million in damages. We're going to get to it in a little bit more detail, but I think there are two important factual points that you need to keep in mind when you're assessing their damages. Number one, I've said it before, they produced nothing but losses from day one until the time they left the country. Number two, the fair market value of their investment was negative $2.7 million. And number three, and this is again very important, this is just it's a factual point, but it's important for you to realize, they had developed phase one. Phase two, it's uncontested. They ran into a number of problems, and they could not do phase two. They didn't have the funding. So they were stuck with a failed investment. And in order to restore phase two, they themselves tell you you need an investment of more than $100 million. So the real question to this tribunal is, what would a willing buyer have paid for that investment? What would a willing buyer have paid for that business, knowing that only one line was operating, that they were only able to generate certain revenues from real estate, that none of that had produced any positive profits for them, and that willing buyer was going to have to come up with at least $100 million in investment before they could ever consider maybe making a profit. Lastly, we believe, and we've proven, that there's no causation, even if you find that there's damages associated with the Lesivo Declaration. Now, let's talk about the legal issues. Indirect expropriation, the question is, and this is a claim of indirect expropriation, has Guatemala violated its obligations under Article 10.7 of CAFTA and indirectly expropriated their investment? The answer is no. In terms of the minimum standard of treatment claims under Article 10.5, has Guatemala afforded fair and equitable treatment to claimant? The answer is yes. Has Guatemala afforded full protection and security to claimant? The answer is yes. Has it fulfilled its obligations for national treatment under Article 10.3 of CAFTA? The answer is yes. And claimant has not proven its damages. Now let's go into indirect expropriation. We all know the standard, and the key question is whether Guatemala indirectly expropriated the investment made by claimant. The main issue, whether or not there's been unjustified and permanent interference with their investment, we submit to you the answer to that is no. And what we think is sort of the clear admission that requires a denial of this claim: has claimant's investment been rendered worthless as a result of the actions taken by Guatemala? The answer is no. They tell you that 92% of their income comes from Contract 402. They still are generating income today. And as it relates to the concrete contracts that they had in place before the Lesivo Declaration, they're all still in place today, and they're all generating more income today than they were before the Lesivo Declaration. Claimant has conceded all of the points that we've put up here on the board, some of which I just discussed. These are key points that tell you that they cannot make out a claim for indirect expropriation. What is claimant's investment? Again, I think a key important issue for you to keep in mind when you're analyzing their case. They've told you the most important part, the bulk of their revenues, comes from real estate. That's Contract 402. That contract is in place. Per their admission, that contract is wholly unconnected to their railway operation business. 92 to 8 ratio is what they say. So, according to their admission, 92% of the investment that generates the most important revenues for them is unconnected with the issues in this case. Claimant alleges expropriatory intent. And we've talked about their issues, their theories as it relates to Mr. Campoyo and as it relates to the use of the Lesivo Declaration as a threat instrument. Again, they're unproven. As it relates to the expropriation claim, both parties agree that the issue of intent alone is insufficient, and in fact, you don't need to find discriminatory intent in order to find expropriation. But you do have to find that there's been interference, and that that interference was substantial enough to constitute an indirect expropriation, equivalent to Guatemala going in and taking their assets away, equivalent to a direct expropriation. The parties concede, both sides, that there was no legal effect on their rights from the Lesivo Declaration. And the very nature of a Lesivo Declaration tells you that. With respect to their rights under the contracts, the parties agree that they still have those rights. Now, there's also no proof of permanency. What do we mean by that? The matter before the Contencioso Administrative Court is still pending, which means the court has not yet determined whether or not the contract is lesivo. If the court determines that it is not lesivo, then claimants have and continue to have every right that they had in the equipment contract. And they could go and they could do a press release and tell all of Guatemala that the government was wrong when it declared the contract lesivo. The point is, at the stage at which we are now, we don't know what's going to happen. The judiciary has not made a determination yet. And until they do, they retain all of their rights in their contract 143. And again, important to underscore that whatever the determination is by the judiciary in the administrative proceeding, they maintain, irrespective of that ruling, all of their rights under contract 402. There's no proof, there has to be proof that there's substantial interference and that it is severe enough such that there has been a substantial deprivation of their investment. They can't prove that because they have admitted to you that they are still generating revenues, they still have their rights in the agreements, and hence they cannot prove, as they allege here, that their investment has been rendered worthless. We submit to you that when you look at the actual evidence that they have submitted, it shows nothing more than letters from some of their clients about potentially speculative investments or projects into the future. None are backed by contracts. None are backed by concrete proposals. None are backed by concrete business plans. And that tells you that these were all speculative, potential projects in discussion and nothing more. There's no causal link between the Lesivo Declaration and their alleged damages, and there are a number of points up there that demonstrate that. But I cite to you the last two. You know, the fact that they, one day after the government declares Lesivo their contract, come out with this press release, one business day, and tell the world that the government has taken action against their agreement, tells you that they were planning for this case to be their exit strategy out of the country. The fact that only months after the government declared the contract lesivo, they are presenting this case before ICSID and conducting another press release before the Guatemalan press, telling the Guatemalan world that they are leaving the country, suspending operations, holding all their legal documents in hand, tells you what their true aim was. Even if you were to find that there is an expropriation, we submit to you everything we've just told you proves that there wasn't. That expropriation is lawful, and they are due no compensation. And it is so because the government has met all of the elements for a lawful expropriation under CAFTA. The Lesivo Declaration was issued for a public purpose. You can point to a number of different things in the Lesivo Declaration, but it's very hard to argue that upholding public bidding laws is not taking action for a public purpose. It's very hard to argue that upholding the Guatemalan Constitution and the organic law of FEGWA that requires executive approval before equipment is given in usufruct is not upholding the public purpose. We've talked about the lack of evidence in relation to their allegations of discrimination. So Guatemala has proven that actions taken were for a non-discriminatory purpose. And as it relates to claimants' allegation that they have not been afforded due process, we know that the Guatemalan law requires that claimant be afforded due process in the contencioso administrative court proceeding, and we know it's undisputed that claimant has made a number of filings, has had its position heard, has won some issues and lost some issues, but the point is they have been given an opportunity to be heard and are being heard and are exercising that opportunity, and you need only look at their filings in that case. We've put some of them before you in Exhibit R336 to prove that. So claimant has been afforded due process and an opportunity to be heard. Now, lastly, on the issue of prompt and adequate compensation, they say the government has not given us any compensation. Well, the answer is that the government hasn't expropriated anything from them. And moreover, they have every opportunity to seek any damages that they may say is owing from an incorrect determination of their contract as lesivo in the administrative court proceeding. And you will hear from Dr. Aguilar. You've already heard from him in his expert report. He tells you they can seek damages there, whatever the finding, and they can seek damages even in a separate proceeding after. Fair and equitable treatment. Here, the standard is articulated in Article 10.5. The important thing to highlight, both parties agree that it's the customary international law minimum standard of treatment that is applicable in CAFTA. Where they disagree, where we disagree, is on what that means and what that standard is. And I submit to you that one of the very important issues that you will decide, legally in this case, is this question, because this is the first CAFTA case to deal with this issue. We claim it imposes a very high burden. There's a very high burden on claimant to prove what is the customary international law standard that's applicable in this case. And it is their burden. It is not ours. As it relates to their reliance on a number of cases that rely on obligations set forth in a number of bilateral investment treaties, the Cargill Award tells you that you can't rely on cases that rely on autonomous bits where those bits don't reflect customary international law. We're not saying it's never proper to rely on a case that makes a determination as it relates to a bilateral investment treaty. We're saying you can only do so where those bits reflect customary international law and not other standards that were negotiated between the contracting states. To do so would be injecting into the minimum standard of treatment, customary international law standard, something other than what should be there. What is the right standard? Well, we submit to you it is the standards that are up on this slide 56. Gross denial of justice, manifestly arbitrary conduct, arbitrary beyond a merely inconsistent or questionable application of an administrative or legal policy, an utter lack of due process so as to offend judicial propriety. That's the standard against which we should be judged in this case. Now, judged against that standard, I think based on the evidence and the comments I've made already, it should be fairly obvious that Guatemala has not violated its undertakings under Article 10.5. But even if the tribunal were to hold us to the standards that claimant says are applicable, Guatemala has not violated Article 10.5 of CAFTA. Here are the standards that claimant puts up before this tribunal. Obligation to afford due process, to provide transparency, to not act in bad faith, to not engage in arbitrary or discriminatory conduct, and to not frustrate legitimate expectations. Again, we say these are not part of the minimum standard of treatment under customary international law. However, even as it relates to these standards, we have not violated them. The evidence in terms of finding of bad faith is simply not there. Guatemala acted at all times in good faith. This is not anything like conduct in the Cargill case where the tribunal there found bad faith. We submit to you that the facts in this case are very different. What they support is that Guatemala acted in good faith Again, claimants cite to their conspiracy theories which have not been proven regarding Mr. Campoyo and the use of the Lesivo Declaration as a threat instrument, but those allegations do not, I repeat, do not have merit. Guatemala, on the other hand, if you look at the actual evidence, it shows that they, at all times, notified claimant that there were problems with the contract, sat down and negotiated with them, tried to arrive at a negotiation that would cure the legal deficiencies. They never overlooked the defects in the equipment contracts, and at the highest levels of the government, they were given every opportunity to sit down with the government and negotiate a resolution. The President himself asked his cabinet to put together a commission to try to resolve the problems, and both up to and after the publication of the Lesivo Declaration, the government at all times acted in good faith. On the issue of due process, I'm not going to repeat it again. I think we've provided ample evidence that they have been afforded an opportunity to have their opinion heard about whether the contract is Lesivo, that they sit here and complain that they should have been given an opportunity to do so before the government, before the President made its determination. That complaint, I think, rings hollow. They signed up for and agreed to abide by Guatemalan law when they made their investment. The Lesivo law was on the books, and they had absolutely no right under Guatemalan law to participate in the process leading up to the President's decision that the contract was Lesivo. Their right to participate came after, and they've been afforded that opportunity. Now, their argument that the Lesivo Declaration is arbitrary hinges on their argument that the Lesivo Declaration, in essence, is an ambiguous determination, that it's not tied to any defined legal standards. They also say that the declaration was not made for a public purpose. I'm going to focus really on the first point because the points 2 and 3 I've already addressed. But as we've said, none of these have any merit. Now, on the issue of whether the decision is an arbitrary one, we submit to you that if you look at the evidence and what was actually done, you will conclude that there was nothing arbitrary about the process. It was a very deliberate process. A number of government agencies looked at this issue. I've already cited them. Independent determinations made. All of this was passed to the President, and with all of this in hand, the President made a determination that the agreements were Lesivo. It wasn't some nebulous determination about whether there was harm to the state. It was a legal determination made and given to the President that important legal requirements were not met in signing this contract. It either is or is not a requirement of Guatemalan law whether the contract should have been done after a second public bid. It is or is not a requirement of Guatemalan law whether executive approval is required before that contract can be effective. Those are legal determinations. Those are not nebulous determinations. Those are not whimsical personal determinations or preferences. The President was advised that important legal requirements had not been met and that he would incur personal liability if he didn't declare the agreement Lesivo because it suffered from this defects. And so he took action. As I said, I'm not going to go over the issues of public purpose and discriminatory intent because I've already covered them, and we leave you to our evidence and the slides on those points. I will just highlight for you that as it relates to the various different agencies that looked at this issue within the government, while there are some differences in the conclusions they reached, there is a remarkable level of consistency in the decisions they've reached. International law doesn't require every agency in Guatemala that looks at this issue to come up with the exact analysis. I think it is remarkable that there is such consistency between the various opinions. And as it relates to the important public interest issues involved, the lack of a public bidding, the lack of approval by the President, the lack of conservation of important state assets, they are all in agreement that these issues were not met and hence that the contracts were Lesivo. And we've put together a table for you, which I won't go through now, but which shows to you the remarkable consistency in the various analyses made, notwithstanding that it's uncontested that these determinations were made independently. On the issue of transparency, the requirement is that, and we all agree on this, that claimant know beforehand the rules and regulations that will govern its investment. The rules and regulations that govern claimant's investment were on the books. The fact that if they entered into a contract, an administrative contract, that violated Guatemalan law, that they would be subject to a lesivo process, is something that they should have known and that they assumed when they went to Guatemala to do business. The law was on the books. There's no allegation here that the law was modified or changed in some way to adapt to their situation. The law that was on the books when they made their investment was the law that was applied to them to declare the agreement lesivo. Now, as it relates to their argument that there are no standards and that they didn't know what the rules were, again, we say that they knew what the rules were. They knew that in relation to obtaining the equipment, they needed to go through a public bid. They knew that they needed to have executive approval before that contract would be effective. There's ample evidence of that in the record from their own letters requesting letter authorizations, from how they acted after the government told them there were problems with the contract. Now, the other thing that they argue in terms of lack of transparency is they say the court has no way to judge whether the president is right or wrong when he makes the determination about whether the contract is lesivo. And they say that shows you there's a lack of transparency and therefore a violation. The problem with that is that in this case, as it relates to the issues that this court has to decide, I'm talking about the administrative court, they're very concrete issues. Again, whether or not a public bid was required, whether or not executive approval is required to give these assets in usufruct. Those are concrete issues that the court has to decide. If it turns out that those were requirements and that those requirements weren't met, then the court is likely to find that the president properly declared the contract lesivo. If he finds that those weren't requirements, then he might find that the president's determination was incorrect. The point is, there are objective, factual determinations that are going to be made by the tribunal in Guatemala. And their argument, by the way, that it's just a rubber stamp is unproven, and we've submitted to you a recent court case from 2010 where a Guatemalan court found that the determination by the president that a contract was lesivo or that an administrative act was lesivo was incorrect. And that shows you that obviously the courts do have standards upon which to overturn presidential determinations about lesividad of administrative acts. Now, as it relates to legitimate expectations, they talk about having a number of legitimate expectations. Legitimate expectation not to have the contract taken away from them to give it to Mr. Campoyo. There's simply no evidence that that happened. Legitimate expectation that the agreement should not be used as a threat instrument. Again, no evidence that that happened. They also talk about a legitimate expectation in not having Contract 143 overturned by a lesivo declaration. I submit to you they don't have any reasonable legitimate expectation in relation to that, because as I mentioned before, when they signed that agreement, they knew they were signing an agreement that did not comply with the very bidding terms they incorporated into the agreement and with Guatemalan law or with the very process that they themselves agreed to follow and did follow in relation to Contract 41. So there has been no frustration of their legitimate expectations. Their fanciful conspiracy theories put aside, there is simply no evidence to support them and no evidence for this tribunal to conclude that there's been any violation of the fair and equitable treatment standard based on those unproven allegations. Moving to full protection and security, the important issue here is whether or not and again, the minimum standard of treatment applies, but the important issue here is whether or not Guatemala took reasonable measures to protect their investment. And the key word there is reasonable. Okay? It is not a strict liability standard, as claimant would like for this tribunal to say. They don't argue it's a strict liability standard, but they point to isolated instances of interference, and they say Guatemala has objected to or has not fulfilled its full protection and security requirements. The evidence is that Guatemala did effectuate reasonable measures to protect claimant's investment. Again, mere interference, mere allegation of a contractual breach is not sufficient. In terms of their allegations about squatting on the railway, first of all, and this is very important, while claimants have put forth pictures and all sorts of other things to say to you that there has been some squatting and some thefts post-lesivo, there is no evidence, I repeat, no evidence from where you can conclude that the squatting and the alleged squatting and the alleged thefts have increased post-lesivo, other than their bare allegation, but that's not evidence. None. There's no empirical evidence that's been put before you to show there are in fact more thefts after lesivo than before, or more squatting after lesivo than before. None whatsoever. And there's no ability for you to conclude that, even though they've asked you to do so. They've also not provided any evidence to link any post-lesivo squatting or thefts to the lesivo declaration itself. There's ample evidence that they themselves were before the press with press releases and telling the world that they were leaving. And quite frankly, months after the lesivo declaration, they abandoned the country and did a press release. Who's to say that that's not what encouraged the squatters and the thefts? Now, in terms of the reasonable measures that Guatemala put in place, we have put before the tribunal a number of documents that show that Guatemala did act in good faith. It responded to a number of situations. We cite here some of the documents that prove it. It initiated criminal proceedings. It filed actions before the Guatemalan courts. It was diligent in protecting in taking measures to protect claimants' investment, and the protestations otherwise simply don't establish a lack of reasonable measures put in place. We cite for you other actions taken by Guatemala here, all supported by documented evidence, and they all show that Guatemala took a number of steps, which, given the standard that's applied in CAFTA, Guatemala complies with its obligation to put in place reasonable measures. On the issue of national treatment, before we get into damages, the issue here, is whether or not treatment less favorable was accorded to claimant than to a competitor or comparator in the country who was in like circumstances. There are three essential elements. They have to prove that there was a domestic comparator that was in like circumstances, that they received less favorable treatment as compared to that competitor, and that treatment related to the establishment, acquisition, expansion, etc. of investments. As it relates to this this claim, we think it's fairly easily disposed of. They are not able to meet either elements 1 or 2. In relation to their allegation that Mr. Campoyo is in the railroad business, we submit to you that that allegation is completely unproven. He is in the sugar industry. He is not a railroad operator. He doesn't operate a railroad in Guatemala. He doesn't operate a commercial railroad in the Dominican Republic. They cite to you the fact that there's an internal railroad that's operated in the Dominican Republic for his own use, not for commercial use. We submit to you that is a very, very different thing than what claimants took on in the railway project in Guatemala. Again, it's in a different country, and we're talking about an internal railway for internal transport that's no more than 12 to 18 miles long, as opposed to the 500-mile long railway that they took on in Guatemala. He's also not and this is just more on the issue of the railway industry, but again, not in commercial operations, substantially different railroads. It's not the same thing at all, not in like circumstances. As it relates to their allegation that Mr. Campoyo was in the real estate business, there is no evidence that Mr. Campoyo was their competitor as it relates to their real estate right-of-way business that they had that was a corollary to their Contract 402. And again, what they say is the most important part of their investment. Mr. Campoyo, there's no evidence that he was their competitor for that real estate business. The only real thing they cite to is a proposal by a company called Desarrollos G, which they received from Mr. Pinto, they say. Mr. Campoyo has said he doesn't know that company. That's not his company. He didn't authorize Mr. Pinto to make that proposal. So, again, there's no evidence that he is their competitor there. But even if you were to believe that Mr. Campoyo was involved in the submission of that proposal, there's no evidence that he's their competitor. What does that proposal say? I submit to you, you should read it very carefully. It is simply a preliminary proposal, and nothing more, a proposal about some possible business ventures between the company Desarrollos G and FVG. There is absolutely no evidence, even if you were to reach the conclusion that they met the first element in defining a competitor in like circumstances, none that Mr. Campoyo has received more favorable treatment or that they have received less favorable treatment than Mr. Campoyo. Again, where is the evidence that Mr. Campoyo is now in possession of their usufruct rights? Where is the evidence that he even asked for it? Where is the evidence that the government even suggested they would give it to him? It's completely absent. That deals with their legal claims. Now let's talk briefly about damages. I'm not going to get into all of the different issues that Mr. Foster put up. I will say to you that we found it interesting that he's asking the tribunal for every latitude when it comes to their damages, and I propose to you that that probably has something to do with the fact that their damages claims are in real trouble in this case. In terms of, before we get into some of the issues that we want to discuss on damages, we do want to point out to you something that we think is quite important for the tribunal to take note of. In the memorial on the merits, claimants sought $64 million. And they said they had lost profits of $36 million and a lost investment of $27 million. After we made mention in our memorial, our counter memorial, that their lost profits were wholly speculative, we'll talk about that in a second. We believe they are wholly speculative. They flip-flopped, and they took a large amount of their damages claim out of the lost profits category, and they stuck it in the lost investments category. And we submit to you that that is something you should look very carefully at and speaks volumes about their damages arguments in this case. Two fundamental questions. If you assume that there is liability in this case, has claimant proven that there are quantifiable, compensable damages that they have suffered as a result of the Lesivo Declaration, and whether those damages, again, were proximately caused by the issuance of the Lesivo Declaration. We submit that the answer is no to both. And again, when you're looking at their damages arguments, it's important for you to remember two important facts. Number one, business produced nothing but losses from day one. Number two, a substantial, more than $100 million investment had to be made before they could ever consider being anything other than a business that produced losses. We submit to you that those two facts show that the analysis done by Dr. Spiller is the correct analysis. Would a willing buyer really pay $65 million for that business? That's what they're asking you to conclude. Really? What's the appropriate standard? The appropriate standard, as Dr. Spiller has told you, is fair market value. And he tells you that the fair market value standard that he utilizes does, assuming that this tribunal reaches the conclusion that the Chorzów full reparation standard is part of CAFTA, which we have not conceded, contrary to what claimant says. But if you reach that conclusion, what Dr. Spiller has told you is that the fair market value, as calculated by him using the discounted cash flow method, that gets you to the same place where Chorzów does. In other words, they are fully repaired, fully receive a remedy for their potential damages in this case. Now, we've argued that claimant misapplies the Chorzów standard, and that leads to a double counting of damages in this case. And the concept, the portion that we argue has been double counted is their lost investment. And the reason that we argue that it's been double counted is that when you do a discounted cash flow analysis of the fair market value of the investment in this case, that takes into account both the possible lost investment and the possible projected lost profits associated with the governmental action. What claimants have done is that they have done that analysis and then they've added the lost investment back into it again. And that results into as Dr. Spiller tells you, counting the same concept, i.e. lost investment, twice, and thus overcompensating claimant. We submit to you that the discounted cash flow calculation is the proper calculation, as Dr. Spiller has told you, and we submit to you some of the sites that Dr. Spiller put before you, and that this does the job of determining what the fair market value is of claimant's investment at the time of the alleged wrongful conduct by Guatemala, and that this would, as calculated by Dr. Spiller, fairly compensate claimant for the damages they seek in this case. Important for you, again, to realize the history of unprofitable operations. Again, that is a very, very important factor in your analysis of damages. It's also important for you to realize that the business termination costs have not been proven in this case. On the issue of lost profits, tribunals, time and time again, are reluctant to grant claims for lost profits when they are speculative, and notwithstanding that claimants have talked to you about the years of experience that Mr. McSwain has, 50 years they say, I submit to you he has no experience in Guatemala, none. And the experience he does have in the U.S. is not translatable to Guatemala. And your best evidence of the speculative nature of the profits that claimant put before you are its historical operations. And these charts tell the story. To the left of the line is what claimants were able to do during the time they were in business. And to the right of the line is what they tell you would have happened miraculously had the government not issued the Lesivo Declaration. Look at what actually was going on at the time of the Lesivo Declaration. Look at the desperation the claimants were in terms of their business, and ask yourself whether it's reasonable to conclude that they were going to generate all of these easements and leases and other contracts. The answer is no. And same as it relates to their rail revenue. It's quite astonishing that their experts tell you that notwithstanding that they were in operations for over 8 years in the country, that if the government hadn't issued the Lesivo Declaration, they were going to shoot up in terms of rail revenue. Again, it's not consistent with the facts. It's not consistent with their admission that they had no way to build the second phase, and that there only was one phase which produced only losses for them. In terms of the double counting, we've made the point already, and it's important for you to realize, and you're going to have a chance to hear from Dr. Spiller and from Dr. Thompson and Mr. McSwain and the other experts, and I'm sure you'll have many questions for them. But as Dr. Spiller has told you, claimant's effort to remedy the double counting by engaging in the amortization procedure that they engaged in their reply brief doesn't cut muster, doesn't get rid of the double counting error in their damages calculations. On the issue of termination costs, we submit to you Dr. Spiller's analysis, and basically most of these costs were not associated, at least no proof has been put forth that they were associated with termination and wind down. Rather, it was operations costs, and therefore are not appropriate damages. Our conclusion, if you assume that if you reach the conclusion, that there is liability, which we submit to you the evidence does not support, you nonetheless should conclude that there are no damages. There are a number of other cases, and we've cited you to some of them, where tribunals have concluded that there is liability, but nonetheless have concluded that claimants have not proven damages, and we submit to you, if you get to damages in this case, that is the appropriate conclusion. Summing up, claimants have failed to prove that Guatemala took any measure that has permanently interfered with their investment, and there's been no interference with the main part of their investment, certainly no legal interference. They have every right in every one of the contracts that they ever got from Guatemala, and there is absolutely no proof, even if you assume that there is interference, that interference rendered their investment worthless. On the issue of fair and equitable treatment, again, their conspiracy theories are not proven. They are theories and nothing more. We ask you to please take a very careful look at the evidence, and we hope will come to that conclusion, because that is the conclusion that we have reached. On the issue of full protection and security, Guatemala at all times used reasonable measures to protect their investment. Again, the query is not, did Guatemala take action with respect to this particular interference or that particular action in terms of a squatter or a theft. It's whether reasonable measures were put in place. And I think that the evidence proves that reasonable measures were in fact put in place by Guatemala. On the issue of national treatment, again, claimants have been unable to prove that there is a competitor in like circumstances, or that any such competitor, here they've only cited Mr. Campoyo, so that's who you need to look to, that they have received less favorable treatment as compared to him. On the issue of damages, again, we submit to you no causal link, no damages have been proven. Claimants still have their contracts. Claimants are today still generating revenues from their contracts. The undisputed evidence is that the revenues have gone up post-Lesivo, and to the extent that claimants aren't generating more revenue from those agreements today, it's because they took a unilateral decision to leave the country in 2007. I remind you, they left the country in 2007 and abandoned their investment. They weren't told to do so, they did so themselves. We believe they're not entitled to any damages. And, okay, sorry, we had miscalculated. I will wrap up then. In terms of prayer for relief, just want to highlight one thing, which is that in addition to the asking you not to award claimants any damages, we do submit to the tribunal that should you determine that any damages are awarded, you should determine that they must first give back the contractual rights which they currently have. Again, they still have them, but it would be completely unfair for them to be given damages for rights and agreements that they still have. Thank you very much for your time.
Thank you so much, Mr. Horton. So we will recess now and come back in an hour's time at 1:20. And if the tribunal will see Mr. Horta and Mr. Forster for maybe 5 minutes before we start at 1:15. Okay, thank you.